Understanding the relation between consent to transfer and consent to charge. What is consent to transfer? Consent to transfer means that when the title to the property is subject to restriction in interest to transfer, the property cannot be sold without the consent of the state authority. Under Section 5 of National Land Code 1965 provides that a restriction in interest is any limitation imposed by the state authority on any powers conferred to a proprietor to deal with land alienated to him or her. As a keeper of all land titles, the imposition of restriction in interest is to ensure that the landowners' interests are well protected and safeguarded. Types of restriction in interest subject to consent to transfer. Number 1, restriction to transfer of an alienated land. Number 2, restriction to transfer bumi to non-bumi. Number 3, restriction to transfer of low cost. And number 4, restriction to transfer of an industrial land. The restriction imposed by the state authority usually endorsed on the land titles documents as follows. Restriction on dealings under Malay reservation land. Malay reservation land, or known as the Red in Grant, is a special category of land within the boundary of state which can only be owned and dealt with by Malays, being the natives of the state. These lands can only be transferred or leased to Malays. This is to preserve the Malay race by prohibiting all kinds of dealing on Malay reservation land with the non-Malays, which means that it could only be transacted amongst Malay, and any attempt by non-Malays in dealing with Malay reservation land will be held null and void. Definition of Malay. A Malay can be a natural person as well as a corporate entity. Article 160 of the Federal Constitution defines Malay as a person who professes the religion of Islam, who habitually speaks the Malay language, who conforms to the Malay custom, and domiciled in Malaysia or Singapore. But for the purpose of Malay reservation land, the definition of Malay will depend on the state legislation and varies from state to state. While Malay as a company has to be registered under the Companies Act 1965, where the name of the company shall reflect as Malays, and all the members and directors shall be Malays with 100% of shares. Direct transfer is another means offered by PTG Johor to assist the perfection of transfer that usually involves layer of purchases of a property and has to be complied within the procedure of the land registry. Process of direct transfer. Consent application must be made and submitted by the transferor, which is the beneficial owner. Once consent has been approved, the preparation form of Party A and signed by the registered owner, who is usually the developer. The transferee, which is the current purchaser, the name will be registered on the title, and registration fees is incurred reflected by the perfection of transfer. Project transfers basically involve with the developers that may happen in three situations: transfer from a developer or a company to a company, where the individual titles has been issued and the project transfers are based on SPKS approval. Project transfers application has been submitted to PTG Johor with certain prescribed fees. With the approval letter issued, then only the applicant shall carry out with the usual presentation, but must be presented as one presentation for that project. Foreign interest consent. Foreign interest under Section 433B National Land Code is an interest of a group. The interest of an individual or a party acting jointly includes 1. Individuals who are not Malaysian citizens, 2. Permanent resident individual, 3. Foreign companies or foreign institutions, and 4. A local company or local institution where the parties in items 1 and 2 have more than 50% voting rights in the local company or local institute on concern. For that, in general, foreign or non-Malaysians are subjected to PTG Foreign Consent Guidelines, which is subjected to the state's authority approval. Before the coming into force of the NLC Amendment Act, Section 433B of NLC provides that no such approvals shall be required in respect of any land subject to the category industry. but with effect from 1st January 2017, a disposal or dealings for any land which is subject to the category industry in favor of a non-citizen or a foreign company is now required to obtain the prior approval of the state authority. In property transactions, purchasers often seek the financial assistance from the relevant financial institution, which is bank or financing companies. Hence, the powers of creating charges are subject to further restrictions as specified in Section 241 of the NLC 1965. Under PTG Johor Circular Number 10/1986 indicates that the state authority has given a comprehensive consent to allow the applicant to make a charge to 1. Federal government or state government, 2. Statutory bodies, 3. All commercial banks trading in Malaysia, 4. All non-commercial banks established under the law, 5. All finance companies registered and transacting in Malaysia, 6. All cooperatives registered under the Cooperatives Act. But what if there is such a charge application received other than the one described in PTG Johor Circular Number 10/1986? How PTG process? Number 1. Application form, a letter outlining the details and documentation to be prepared by the chargee and submit to PTG Johor. Then, PTG will get the papers ready to be presented to Jawatan Kuasa Hasil Bumi. Once it's approved, then only the applicant will be notified and only then the charge can be presented to PTG Johor. This has been a best approach and best practices by PTG Johor and relatively the only PTG that comes with this best approach and practice. Should you have any inquiry regarding land matters, do reach us out at Kindly share this video to everyone. Thank you.